Wouldn't justify any force.
Right.
It wouldn't justify a push on the shoulder against the wall. It wouldn't justify slapping the phone out of your hand.
Yeah.
It wouldn't justify any action by the police. The police have a tough job.
Sure.
It's tough. What they do is tough. They have to deal with the idea that today citizens are going to film. In Philadelphia County, there's poll cams everywhere in the city. Everything is getting recorded.
Welcome, Brian.
Thanks, Todd. Thanks so much for having me. It's a pleasure and honor to be here.
Yeah, thanks for coming. We go back a little ways. We went to law school together, and we're getting a little grayer now. So it's been a while, huh?
Temple Law, go Owls.
Absolutely. So tell me about what you've been practicing since the good old days of law school.
Yeah, I do civil rights cases, which basically means they're cases where we sue the government. We do police brutality cases. We do police misconduct cases, false arrest, malicious prosecution, correction guards in prison facilities use excessive force or medical deprivation cases against prisons. We also do municipal liability cases where we sue the municipality for failure to train and supervise the people.
Okay. And where do you practice?
Well, my office is located in Philadelphia, but we do have very small locations in Pittsburgh and near Princeton, New Jersey. I'm licensed to practice in all the federal courts in Pennsylvania and New Jersey, and also in the Northern District of Ohio, the Western District of New York, the Third Circuit Court of Appeals, and the Supreme Court of the United States.
Right. That's a good exhaustive list there.
Yes, sir.
So what made you decide to get involved in this kind of law?
I used to do a lot of criminal cases, and we still do have sort of a good amount of criminal work in the office. And I was sort of in charge of all those, and I was the main person. And I also did a lot of criminal appeals, and we still have a good amount of criminal appeals in the office that involve a lot of writing. And we would always get these calls for civil rights cases, and we sort of sent them out to other firms. And the more experience I got, I realized that what's going on in the civil rights cases is actually very similar to criminal appeals. But there's like a jury trial element, and I've done a lot of jury trials. And so I thought, these cases are really perfect for me. I should really start doing them.
Right.
And so then instead of sending them out, we kept them all.
Okay.
And then the more sort of great results we had for our clients with really big numbers, we decided, boy, this is a way better way to serve the community,
right,
and the people in our community than it is me doing criminal cases. So we should do this and sort of help people in the community and make sure that if their civil rights are violated, that the government's held accountable.
That's great. So you wanted to help people, and this was the best way you could find to do it.
Correct.
Okay, that's great. That's what we like to do here too. That's what kind of drives us, is helping people that are injured and don't have, that need somebody to fight for them against the big companies, big insurance companies. And it's kind of the same with you. You're fighting against government. You can't get much bigger than that, right?
Exactly.
Okay, that's awesome. So I want to ask you, I want to focus, I know you have different practice areas like criminal law and things you talked about, but since it seems to be in the headlines these days, I want to kind of focus on the excessive force part of your practice. Okay.
Right.
And is that kind of taken over as the main practice area of your firm? Or?
I would say that the excessive force cases are a big one, whether it's by police or correction officers. And then the medical deprivation cases are equally as prevalent. The medical system in prisons is terrible, and people are deprived of basic medicine all the time in prisons throughout the United States. So those two subject areas are sort of like the big ones.
They kind of, both feed off each other.
Right. We do all the other kinds of civil rights cases related to law enforcement,
Right.
But those two are really the ones we have a lot of.
Okay. And I kind of want to jump into the heart of the issues that I see people arguing about, on Instagram and Facebook and things and this can be a sort of a polarizing issue, right? Because on the one hand, you have people that, sympathize with the police because they have a dangerous job, right?
Sure, of course.
And of course, they want to get home at night and get back to their families, and there could be dangerous people out there, right? But then on the other hand, you need to balance that with not going too far where you would injure people that shouldn't be injured, right? I mean, that's basically the the balancing act of these
It's in the
cases?
mid 90s, in my experience, or the low to mid 90s. Say like 92 to 95% of police officers, the best human beings on the planet, they would do anything for you.
Right.
They would climb up a tree to get your cat. They would help you out of a window of a burning house. They would step in front of traffic for you. They would do anything for you.
Right.
It's the other percentage ones where the force seems to be in excess of what would be reasonable.
Okay. And so you're not anti-police, but you're there to make sure that people's rights are protected and, that they don't go too far and trample upon people's constitutional rights, I assume.
Right. We're not against police in any way.
Right.
And the common misconception, we're not against police at all in any way. But the standard is that there's this 42 U.S.C. 1983 is the Civil Rights Act.
Right.
There has to be a constitutional violation, and a member of the government, a state actor, has to be personally involved in the constitutional violation. And the law for the constitutional violation has to be established in the circuit in which the case is brought.
Right.
So excessive force is looked at as a Fourth Amendment violation, like an illegal seizure of your person. You have to name the actual officer who used excessive force by name, and you have to say, this is what they did, and here's the damage that I have as a result of what happened.
Right.
And you file that in federal court.
And these cases seem very fact-dependent from what I see. So is there some dividing line that you commonly see where, on this side of the line, the police officer is justified in the force they're using? And then, at what point would you say it most commonly would go over the line from your perspective as a civil rights attorney, where it would then be excessive force and someone's rights are violated?
It's two separate ideas.
Okay.
To answer your question. So one is, I think there's an idea called the force continuum. Not every jurisdiction would phrase it that way. Some places would say the use of force policy. But I look at it as a force continuum. A police officer is allowed to use an amount of force that's greater than the amount of force that they're faced with. There's basically four categories, right? There's commands. The police officer is telling the person to do something. The second is control holds, meaning their hands and feet. They're punching or kicking someone or pushing them up against a wall, right, in order to detain the person or handcuff them. The third is non-deadly force. Examples of non-deadly force would be a taser, a baton, an asp, pepper spray, OC spray, things of that nature. And then deadly force, which would be a car or a gun. And so a reasonable police officer would be using an amount of force greater than the amount of force they're faced with, okay, in order to do their job. The second answer to your question, though, is there's something called qualified immunity. And what qualified immunity means is that if qualified immunity is found, then the officer's immune and you can't collect on them. And in the Third Circuit, there's like a list of, say, 10 or 12 factors that are considered for qualified immunity, like what's the officer facing? Are there civilians that could be in danger? Are there other officers that could be in danger? Do they know the person? What other factors are there? Is the person known to be armed and dangerous? What kind of case are they investigating? There's all these factors. So if they use force that seems like it could be a little too much from that first paradigm, but they're sort of in the guise of qualified immunity, then you're going to lose. Okay. So
it has to go far beyond what that greater force that is being directed toward them.
Sort of. Okay. Yeah. Okay. Yeah. In a sense.
Okay. So there's sort of a buffer zone where they're in the sort of the safe harbor.
And in a sense, yeah. I think about it like intentional conduct that goes sort of beyond what you would think a reasonable police officer would do. So if you see the officer doing something intentional that's beyond the scope of their job, they don't have qualified immunity, the amount of force they use is in excess, it's a good case. We're going to make a recovery for the client. An example is there's case law that says if someone's restrained, meaning handcuffed and shackled, they basically can use almost no force against the person, even if they're not compliant.
Because there wouldn't be a threat against them.
Right. So so the officer's never going to have qualified immunity if they hit someone while they're handcuffed and shackled, even if the person's out of control and they're not compliant. The issue is, you've got to show, though, still that it's excessive force. and you still have to show the person has an injury, of course, because we're talking about suing someone.
Right. That would be the damages part.
The damages part.
That comes along after the violation of the rights.
Correct.
Okay. All right. So what is the danger, or what would you say to somebody that says to you, well, police have such a tough job, right? And it's dangerous, and they're going into these dark houses or abandoned buildings, and they know that there can be bad people in there that can hurt them.
Right.
And they make a mistake, and maybe they shoot somebody or they hurt somebody, but that's the nature of the job. They're trying to protect themselves, right? But what is the danger, say, if there is no one to check that kind of behavior, right? Like, what is the danger to society or to people in general if there's no rules about the force that police can use?
Well, I don't do personal injury cases, but my answer is a personal injury answer. I think that jurors are the guardians of our community.
Right.
So when you're there for jury selection and you agree to sit on that jury and you don't get struck during jury selection and you're seated on that jury, you have a job to keep our community safe.
Right.
Right. And so you, as the jurors or the guardians of the community, you have to hear the testimony and then you have to do what's right. Now, in some of the scenarios you gave, police do have tough jobs. There's no question about it, especially today. Okay. But today we see the vast majority of police officers have body cameras on that are activated. So we see exactly what they're dealing with. So it's no longer he said, she said. It's we see what the police officer has to do. And a lot of times it leads us to watch the video and say, that's not a case. Or it leads the other side to say, ooh, we should settle this.
Right.
Like this isn't going to go to a jury trial. In addition to that, the scenario you gave, a lot of those elements of qualified immunity sort of ping in that scenario where they're going into an abandoned house with bad guys and it's like, what are they encountering? What do they deal with? Right. So, you have to deal with all those things. But the answer, I think, to your question really is jurors are the guardians of the community. You fight your case, you put your case up, you call it ready in court, and then you let the jurors decide, if what the police officers did is wrong, and then, of course, how much it's worth.
Right. And I assume, from your perspective, you're protecting fundamental rights of Americans. Mm-hmm. And do you consider that sort of protecting democracy in a way? It's if you can't let the government go unchecked, would you?
I agree with that. I call that defending the Constitution.
Right. Right. Okay.
I know we're plaintiffs' lawyers. We don't do defense, but I call it. When someone asks me that question, I say, well, you have to defend the Constitution.
Right. Okay. So it's a real balancing act between the officer's safety and people's rights and people not being injured unnecessarily.
Well, all the case law is in favor of the officer's safety, like 99% of the case law.
Right.
So anytime the officer's safety is even in question, I'm going to lose.
Okay. Right.
So officer safety is at the very peak of the mountain in the United States of America. We do everything we can to keep officers safe.
Okay, that makes sense. So getting the damages, in our cases, it can be difficult for a jury to say, well, how much did this person suffer from pain or suffering? It's hard to put that into a dollar, right? So what we try to do is show a picture, a snapshot from before the incident where they're injured to how their life is different after the incident, right? Like what was taken from them because of this incident. And it could be they can't work now, or they're limited in working, or they can't enjoy hobbies or activities, or they can't interact with their husbands or wives or children or something.
Sure.
To try to give some kind of snapshot of it. Is it similar to that in your cases?
It is similar to that, but that's not my style. Uh-huh. I respect what you just said, though. I get it. I think so. We get so many calls for civil rights cases all the time where people have had their civil rights violated, but they're not hurt at all. There's no damage. They weren't incarcerated, or maybe they were incarcerated for a couple hours or something. It's a very sort of like no damage situation. We generally don't take those cases.
Okay. That was going to be my question. Like, is there some value to just your rights violated, but you're not injured?
There is.
Yeah.
but not for me.
Right.
We have too many cases, but too many people we're trying to help, and we can't take those cases. We do always have a couple of them because they're either clients of the firm or someone we feel really bad for or whatever, but we really try to not take those and really limit how many of those non-injury cases we have. And then once we take a case where there's real injuries, like physical injuries or a person's been incarcerated for years falsely or something like that, our case strategy when we sign up the case until the end, whether it's settlement or trial, is we're constantly building the damages. We're constantly working on building the damages. Our whole case theory goes to damages the whole time, not the liability.
Okay.
Right? And I think that our whole presentation to the jury is about damages.
Okay.
We're not squabbling with the lawyers on liability. They want to fight about liability. The defense lawyers for the government always want to argue the police are justified, they have qualified immunity, whatever. And our whole opening and closing questions, all we ask, everything we do is about damages from beginning to end of the case.
Is that because your cases that you take are so far over that qualified immunity that you don't think that's a big issue? Or
I think it's how I get my clients paid the most money.
Okay.
Like my attitude is, of course, their civil rights were violated.
Right.
Qualified immunity isn't a question. We're not here to talk about qualified immunity. We're not here to do any of that. We're here to force people to accept responsibility for their actions and make people whole.
Okay. All right.
Right? Like in other words, if you had a car accident where someone was paralyzed, if you opened with this person's, paralyzed, everything that you did in your car accident case was just about the damage, and you focused very little on liability, it would have a completely different impact on the jury than it would doing it in a more traditional way where you're going through every step of what you think you have to prove for your case.
I see. Yeah, that makes sense. So you're basically just
stylistic.
You're just basically assuming the liability part, and you just want to talk about what it did to this person.
It is a stylistic preference. It doesn't make me right.
Right.
It just means that's my style in the courtroom. As you and I have discussed, I've done probably over 150 jury trials as lead counsel.
That's all
right.
Great.
And so I am very keen on the jurors and jury selection and their body language and what the jurors expect.
Okay.
So it's like theater. So I'm putting on a presentation for those strangers on there, and I think they want to hear about damages.
And you're reading their body language to see what you think they're interested in.
Because civil rights cases, unlike car accident cases,
right,
civil rights cases are per se interesting. Right. So when we go over the facts of the case, the jurors are all paying attention. No one's so on liability, it's like the case speaks for itself, right? We're not taking the case unless there's liability.
Sure.
So where in car accidents, it's a totally different thinking.
Right.
Right.
You have to, we find that you have to really get to know your clients, right? Because you have to know their story and their life story.
For sure.
So that you can portray that to a jury because they don't know your client, right? They're strangers. So they need to know your client to be able to embrace them and love them and want to help them and want to compensate them for their harms. Is that the kind of same thing in your cases?
Same idea, yeah.
Okay. All right. Good. So there's been some high-profile cases in the news lately. I just kind of wanted to, while we're talking about excessive force cases, right? I just wanted to kind of see from a civil rights attorney's perspective, what your take is on these cases that have been in the news in Minnesota.
Right.
Okay. So can you just tell me from what you've seen, we've all seen the videos and things, right? And you can take it one at a time or talk about both if you want. I'm talking about, the Renee Good and the Alex Preddy cases, right?
Right.
So what do you see as far as, excessive force issues in those cases?
So first of all, just so we're clear for the show, these are both people that are American citizens.
Right. That's right.
Okay. And also to be clear, ICE they're federal agents. So the standard's a little tougher against federal agents for civil rights cases. You have to do what's called a Bivens action, which is a little different than 42 U.S.C. 1983 because they're federal agents, not state law enforcement officers. So It's a little different. However,
Right.
the analysis is basically the same, okay, for purposes of our discussion here today.
Right.
So the woman in the car, I don't know what's going on there. There hasn't been enough information, in my opinion, from ICE telling us what happened there, what was going on.
What led up to it?
What led up to it. Now, a car is considered to be a deadly weapon.
Right.
So is there footage? Is there evidence somehow that the ICE agent thought that they were going to be run over by the car?
Right. That's
Because
a big question in that case.
Right. Because if the ICE agent thinks they're going to be run over by the car, they definitely can shoot at the car without question. Then it's just not a case.
Right.
It's not even a case to take. It's not even a case to file, right? If they have a reasonable belief that they're going to be run over by a car, they can open fire, period. Okay? Now, or is it that she was blocking their ability to apprehend someone that they were on a manhunt for? I don't know the answer to that. If that's the case, then no, they're not justified in shooting her. That amount of force is greatly in excess of what would be reasonable at all for any time.
They would have to be facing some kind of danger for it to be justified.
Well, it's like the force continuum we talked about before, right? There's an amount of force they're faced with.
Right.
They're allowed to use an amount of force greater than that in order to subdue the subject, right?
Right.
So if they think someone's going to run them over and kill them, they can try to kill them in their own defense, because we're always trying to keep police safe.
Right, and that makes sense.
It makes sense,
Right.
of course.
Right.
But if there's no harm to the agent, then they can't use any force really, except like verbal commands or control holds to be like, "Lady, move your car."
Okay.
Right. And now, if they want to arrest her for obstruction of justice, then arrest her for it.
Sure. Correct.
So I don't know what happened. We don't know as of today, the day we're filming this, what happened there. That's not out.
We haven't gotten all the statements and things like that.
Correct.
Yeah.
Now, the other case, the guy that has the cell phone in his hand, we see cases all the time where someone has a cell phone out and they think it's a gun or whatever. To me, that seems like pure excessive force.
Right.
In fact, that may even not be a case, because really the ICE agent should be indicted or arrested and charged with something criminally. And if that happens, then the government may not indemnify the agent, and then you can't really sue someone if there's no money to get, as I'm sure you're aware. Like if there's no insurance in a car accident case, it
makes it difficult.
Right. So that is so egregious that it seems very clear to me that officer should be in criminal court somewhere. Whether it's federal or state or indictment or arrested, that's a different discussion for a different time.
And would that be because there's really no indication in the video, at least, that he was ever putting the officers in danger?
At all, and he had no weapon in his hand. He had a cell phone in his hand, and it's clearly a cell phone.
Right. Now, some people say, well, he had a gun on him. And if an officer sees a gun in his waistband, I mean, the officer might be afraid for his safety, right? Somebody might say, is that enough to justify what went on in that case, in your opinion, as a civil rights attorney?
Well, you'd sort of change the facts, because that's not what happened in that case.
Okay.
He did not have a gun. It's on video.
Okay.
So, like, video doesn't lie.
So
he did not have a gun. So the idea that
at the time of the shooting,
right? What your question was, what you started with,
right?
At the time he was killed by the ICE agent, he didn't, in fact, not have a gun on him, because there's no gun in the video. He has no gun in his hands. There's no gun. That's a false narrative. That's fake news.
Okay. I think maybe I'm wrong.
Right.
I thought I saw from the video that he had one in his waistband. Now, he didn't have it out and wasn't pointing it at anyone. And then I think I saw that one of the agents took the gun and walked away with it before the shooting started.
Well, okay. Right. But
so
at the time,
you're talking about at the time the shooting happened, there wasn't a gun.
At the time the force was used by the officer.
Right.
And there's a constitutional violation by the officer of excessive force. He had no gun on him.
Right. I see. So we're on the same page. Right. Okay.
So in my mind, I don't see, it's a per se civil rights case. But again, I think the officer should be arrested for something.
Right.
Like, I think if that happened in Philadelphia County, I think he would have to deal with a criminal case in state court.
Okay. Now, I've seen some people on social media say, well, he FAFO'd, right? He shouldn't have been there. He shouldn't have been bothering the officers or filming them or doing those kind of things. And that can happen if you do that. What would your reaction be?
that you have a First Amendment right to film officers, that you have a First Amendment right to ask an officer a question. The officer, doesn't have to answer,
Right.
But now you can't threaten an officer. That's a crime. You can't do that.
Right.
But you can question an officer. They don't have to answer you. You can video record an officer, and it's not a crime.
Right. And doing that wouldn't justify being shot and killed.
Wouldn't justify any force.
Right.
It wouldn't justify a push on the shoulder against the wall. It wouldn't justify slapping the phone out of your hand.
Yeah.
It wouldn't justify any action by the police. The police have a tough job. It's tough. What they do is tough. They have to deal with the idea that today citizens are going to film them. Right. There's in Philadelphia County, there's poll cams everywhere in the city. Everything is getting recorded. Right. The vast majority of officers in Philadelphia County want to have body cams. They want everyone to see what they deal with.
Right. So and if somebody makes an allegation against them, it's not true. They have a defense.
We have cases all the time. We file in discovery. The city gives us a video. We see what really happened. And we drop the case.
Right. I appreciate the objective viewpoint you have on both of these cases because, unfortunately in our society, it seems that things are so polarized politically, right? Like either you're 100% on the officer's side or you're 100% on the citizen's side. And as lawyers, we need to be objective and look at the facts and draw opinions and conclusions from that, right? I mean, that's what we do for a living, right?
I try to be in the middle. Yeah. Try to, just like you say, I look at the facts and call it like I see it.
Right. I appreciate that.
It's not illegal per se to possess a firearm in the United States.
Right. Right. That's another issue there.
No, but it's not, right?
No. Yeah.
So there's three ways that we regulate guns in the United States, right? It's who can possess them or not, how you possess them on the person, and the type of weapon that you have. We regulate all three of those, right?
Right.
If someone has a mental health history of being committed, if they're a previously convicted felon, they're not allowed to have one at all, right?
Right.
And then, whether in some jurisdictions you can have one in your house but not on the street,
right? And
then in some jurisdictions you need a license to carry concealed outside.
Yeah.
Some jurisdictions you don't. They have open carry, right?
Right.
Then but if you have a rifle, it's not concealed. That's
okay. Yeah.
Right. That's okay. Then we talk about the size of the gun. We talk about how many rounds are in it, what the gun can do, semi-automatic. All these things, are different in all the different jurisdictions in the United States. So, if you're in an open carry jurisdiction, and you have a gun holstered on your waistband, that's not even anything that justifies the police even stopping you.
Right.
Right. And the police can have a mere encounter with anyone they want, but you can just be like, I'm not talking to you. But for them to stop you, they have to have reasonable suspicion that either you're armed and dangerous or that criminal activity is afoot.
Sure.
Well, if you have an open carry jurisdiction, the fact that someone has a firearm on their side doesn't make them dangerous. It just makes them armed.
Right.
Now, if you're in a jurisdiction where you need a concealed carry permit, like in Philadelphia, right? If someone has, just because someone has a gun holstered on their hip, doesn't give the police officers any justification to stop them for that either.
They're not
accurate.
Yeah.
And there's plenty of case law on that point. Yeah. So the fact that the guy before this happened in Minnesota had a gun holstered on his hip,
right?
The guy has a Second Amendment right.
It seemed like it was irrelevant. Yeah. So Brian, to get back to the gun issue, right?
Yeah.
And I know you said at the time the shooting started, Mr. Preddy didn't have the gun, so there wasn't a threat. So that's really irrelevant whether he had the gun before that. And does anything factor into this, about that people have a Second Amendment right?
Well, the fact that someone possesses a firearm lawfully is not any crime. The same way you have a First Amendment right to film the police, you have a Second Amendment right to possess a firearm. Some jurisdictions have open carry. Some jurisdictions have concealed carry. But if you're in compliance with the law, it doesn't give the officers any reason to do anything to you other than to have a mere encounter, which you can decline as a citizen.
So just because they see somebody with a gun, that doesn't give them any justification to start using force at that point, only if the gun is used in some threatening way. Would that be accurate?
Some threatening way, or that they had information the person was dangerous, or that they had information that criminal activity was afoot. But think about in very rural jurisdictions, very rural areas in the United States that have open carry. I mean, people carry guns holstered on their waistband every day as a matter of course.
Or up in the back window of their pickup trucks, right?
Right. I mean, that doesn't.
Right.
That's the Second Amendment. That's not a crime. That doesn't give law enforcement any reason to interact with you per se.
Right. There would be a lot of shootings if just seeing a gun justified the use of force, right?
Right.
Yeah.
Exactly.
Yeah. So for the Renee Good case, some people are saying, well, the officer was in front of the car for a time. It appeared from the video, at least. That's what people are concluding. And some people are saying, well, that's against policy or against police procedure. They shouldn't put themselves in harm's way, right? So if the woman decides to flee, she may not mean to run him over, but he's in harm's way, right? So does that factor into the equation at all?
Not really for me.
Okay.
It's really about whether the force was justified.
Right.
And I really still maintain that we don't have enough information about that one.
Right. And he was in front of the car for whatever reason, so if it's coming toward him and he felt it was a threat, then that could conceivably justify the use of force.
Absolutely.
Okay. And then some people say, well, maybe the first shot was okay, but then he shot 2 into the side of the window, right, when he's not in front of the vehicle. So and that brings up an interesting question. So if the use of force is justified for a period of time, right, is there a point where if the threat goes away, right, that the use of force has to also lower or decrease, I should say?
There's a whole body of case law on that question.
Okay.
And we've had that case where the police officers are justified in maybe the first or second shots at the guy, but then they unloaded about 700 more rounds into the guy.
Wow.
And the autopsy was not clear which bullet took the man's life. Definitely, after the second shot, he was totally subdued. They did not need to fire another 700 shots at the guy.
Okay.
So the case law is very favorable for the plaintiffs in that scenario. Right. So your question is kind of specific. I'm giving kind of a general answer.
Sure, no, that's fine.
But the answer is you're on to something for sure.
Okay.
And the case law is good for us.
Okay. And that was sort of implicated in the Freddie matter too, right? Because, but I know it's your opinion from looking at the video that even the first shot was unjustified, right? But then they shot, I think, 10 times more, right, approximately. So that same kind of issues are raised in that, but also, or
that's a little different than the 700 round example I gave because in depositions I've taken on that issue, the officers all testified that they are trained to unload their clip.
Okay.
To make sure the person's subdued because officer safety is the number one thing.
Okay. Yeah, I wasn't aware of that.
So if it's a municipal actor, not an ICE agent, then you can have a claim for failure to train and supervise against the municipality to say that they shouldn't be trained to unload their clip because they could have shot the guy one time, or twice, he would have been subdued, and then they could have, and he would still be alive.
Right. So just because they're trained to do that, does that mean that's proper?
It's a separate cause of action.
Okay.
Than excessive force. It's an actual claim called Monell, and the theory of Monell has to be either failure to train or failure to supervise. So failure to train is what you're talking about. Failure to supervise would be like there's a rogue police officer that's had like 20 of these excessive force cases, and they're still on the force.
Okay.
Failure to train, failure to supervise.
That's an interesting answer because that brought me to another question I wanted to ask.
Sure.
What do you see as the most common cause of situations where the officers are liable for violations of civil rights? And I was going to say, is it a training issue, or is it where officers are bad apples, or a combination of the two, or something else?
In my experience, it's just situational where the officer sort of loses their temper.
Okay.
Or they're one of those, 5 to 8% of officers that are a little out of control.
Right. Okay. That's fair. All right, Brian. Well, thanks a lot for coming.
Thanks.
It's been very interesting and informative. I've learned a lot as a lawyer, so I hope some other people learn something from this also. And if somebody has a case like this, how would they get in touch with you?
You could go to my website, which is brianzeiger.com. It's BrianZeiger.com. Or you can go on Instagram to Zeiger Firm.
Okay.
And send me a message.
Great. It sounds like they'd be in good hands. You've done it all with these cases. 150 trials is no joke. Sounds like a lot of work.
A lot.
But congratulations.
Thank you. Thanks again for having me. It's really been an honor to be here.
Absolutely. Thank you.